speaking with me, Tarun Nagia. Today, on the part 2 of our series on the use of black money law, we refer to the judgment of the Karnataka High Court authored by Justice Nagprasanna, where he said that use of black money law retrospectively is unconstitutional. This judgment impacts thousands and maybe even lakhs of people who have accounts abroad, and that is why it is important to understand why this judgment was authored, what are the implications for all 30 states of the country, because India has the largest number of people doing business abroad. We also have a huge population that works abroad. Accounts have been held by Indians abroad since decades now. All of this and more on today's show. Let me welcome my panelists today. Justice Chella Kodandram join us today. He served as judge of the Telangana High Court, now is a practicing senior advocate at the Supreme Court and various high courts. Good to see you, sir, and looking forward to some interesting insights from you on this. I have with me Ramya Suresh. She's a partner with one of India's leading law firms, namely Saraf and Partners. She joins us on this show for the first time. I welcome her on the show. Thank you for coming, Ramya Suresh, on the show, and looking forward to some interesting insights from you as well.
Thanks.
At the outset, may I request Ramya Suresh from Saraf and Partners to explain the judgment for a bit, and then we move on with the discussion. Over to you, Ramya.
Sure. Thanks, Tarun. Thanks for having me. Nice to meet you, sir. So to quickly go through what the judgment talks about, it's dealing with multiple petitions which deal with people who had in the past accumulated assets or financial interests abroad and had received notices from the tax authority under the provisions of this legislation for disclosure of those assets and eventual imposition of tax on those assets. Now, what is peculiar in the batch of petitions that are all combined in this judgment is that in all of these situations, the acquisition as well as disposal of these assets had happened several years before the legislation came into effect. To give you the dates, the Act in fact came into force on 1st July 2015. Now, the case that is considered in that particular situation, the acquisition had happened much before the Act came into force. In fact, even the disposal had happened back in 2010, 5 years before the Act was even enforced, which is what is in fact a significant fact which has driven how the lordships have considered the judgment and have the case and have passed their judgment, which is to say that these cases will not fall within the ambit of the provisions of this legislation. Tarun, you're on mute.
Thank you. Thank you, Ramya, for your opening comment. I'll go to Justice Chella Kodandram for his opening comment on the show. Over to you, sir.
Thank you, Tarun, for inviting me to this talk. In fact, I'd gone through the Act as well as the judgment. This Act is of the year 2015, and the judgment relates to a batch of cases. Frankly speaking, the learned judge in a criminal petition went on to say about whether it is a prospective or retrospective. Maybe what was in challenge before the court was only the prosecution notices or the prosecution with respect to the prosecution, and it's a little strange. Normally, without there being a challenge to the provision, the court doesn't enter into the validity or otherwise of the provision. But nevertheless, the learned judge went on to discuss. But so far as the conclusion is concerned, I concur with the conclusion for the simple reason, when you look at there's a prior to this, there's a Benami Transactions Act, which is of 1988 Act. And there was an amendment which was brought in 2016, bringing in various aspects. of the Benami transactions, and there was also a prosecution provision there also. Fortunately, Justice Buyan, sitting in Andhra Pradesh, in the case of Nexus Feeds case, while following and noticing that the conflict of opinions rendered by the Calcutta High Court and Chhattisgarh High Court, where the Chhattisgarh High Court had held retrospectivity with regard to Benami Transactions Act, Calcutta High Court had said it is only a prospective, and thus the penal provisions do not apply. The court in the case of the Union of India versus Ganapati Deal Comps Private Limited case in 2022 had categorically held that it's an elaborate judgment of Justice Honorable Chief Justice the then N.V. Ramana, elaborately held that these kind of acts cannot be retrospective and they have only prospective, and therein there's an element of elaborate discussion. So as I said, so far as the Karnataka High Court judgment is concerned, we have touched upon a bare minimum, but probably it's a more elaborate discussion one would find in the case of Ganapati Dealcom Private Limited. Essentially, what has been held is the, in fact, accepting Dr. Singhvi's argument, and based on Article 20 of the Constitution of India, that cannot be given retrospectivity with respect to the various acts. Operation of the penal provisions and this kind of prosecution can be only prospective.
Thank you for your opening comment. I'll take this to Ramya Suresh. Two things that I want to know from you. Indians have been holding accounts abroad since decades now. And there are many Indians who are, say, the kith and kin. Basically, if the brother has moved abroad and opened an account and the nominee may be a relative in India, maybe the younger brother, maybe the elder brother, or other relatives. And they have then assumed the account in case of somebody passing away. Many times, legally, people are not aware. Do you think that we see these kind of litigations in Bombay High Court recently? Other high courts have also been witnessing because of notices by the income tax. What are clarity in your view, and what are possible problems that we may have which may need clarifications also? Do you feel that Supreme Court will get an opportunity to club cases, or will it avail that opportunity to club and clarify things? Because otherwise there would be cases that would be filed in many states as and when the tax department starts to issue notices, be it Andhra Pradesh or Tamil Nadu or Karnataka. Now in this case, earlier happened in Maharashtra. If you could explain this, so the businessman and the account holder can understand what's going on.
Sure, Tarun. So there are a couple of things to sort of address in the series of points that you just mentioned. First is vis-a-vis where this judgment will progress. Is it a potential for a Supreme Court ruling in this or other batches of matters? Now, this particular judgment, as I said, is a judgment on a batch of petitions. Now, it was feasible to combine those because the fact pattern in them was largely the same, which is the acquisition and disposal being before the act coming into force. So as long as that sort of similarity exists, I think should this matter go further, the possibility of them being treated simultaneously does come up. There are, if I'm to my knowledge, I believe there are some petitions that are already pending with the Delhi High Court, and there may be matters similar in other courts as well. But I think the two key facets that are relevant in any ruling on this aspect, taking a cue from what the Karnataka High Court has passed in their judgment here, is number one, whether there was any requirement to disclose the foreign assets at the time when the individual held those assets. That's number one. Second is whether the asset was diluted or disposed of or extinguished before this act came into force. These are the two main aspects which were before a consideration, which were up for consideration before the court, and which drove the conclusion to which the court landed. So for anybody else who's looking to take guidance from this judgment, these are the two main aspects to consider: whether they are the account holder or the beneficiary. There are multiple regulations under which they will be required to comply and disclose their assets, right? So if at the time when they have held the assets, if there is an obligation to disclose, let's say for example this act which required disclosures of previously acquired assets once the act came into force. So if at the time, let's say 2015, if 2015 or later you've held assets which, and at the time there was a need to disclose those assets under law, and you of course hadn't disposed of the assets, then the exposure potentially to receive similar notifications and subsequent assessment and prosecution under the act may still very well be the case. Because there, the challenge is it's not so much a discussion on prospective or retrospective. When the act came into force, the requirement was to disclose all assets held which haven't been disclosed. So therefore, the application of the act starts from there. So unless you held something before the act came into force and you disposed it off as well before the act came into force, anything else will still, in my view, fall within the applicability of the scope of this legislation. So that's what people with assets overseas need to be mindful of. That as long as they held the assets and there was a requirement to disclose, they should have, or the acquisition and disposal should have happened before the act came into force.
So thank you, Ramya. So as what Ramya says, that the disposal should have happened before the act came into force, if I'm right. I'll go to Justice Chella Kodanram for his intervention on the same question.
Well, see, the Act has provided a window, and the Act has specified a date of first day of April 2016, such declaration to be made. So anything you discover thereafter would attract, this Act would attract. And at the same time, to what extent Section 59 and also read with Section 72 per se doesn't give any retrospectivity. It only speaks about a particular transaction and how it applies. So it's a crucial aspect would be Section 59, and further at what stage the discovery is to be made. So far as my understanding is concerned with respect to any discovery that it may be made after the act coming into the effect, and not somebody not utilizing the window which was open. So far as the individual who is alive, or so far as the other people who are not aware of, the family members or others, that is a different issue. So far as the individuals who are aware and in whose favor or in who had such accounts, if they get discovered, naturally an act gets attracted. And then thereafter, there's a procedure with regard to the issuance of notice and making an assessment and tax liability being imposed along with the penalties and the whatever is applicable laws both under the Income Tax Act as well as under this Act. No, I'm not able to hear you. Your voice is not coming.
Do you see the Income Tax Department escalating this to the Supreme Court? And in that event, do you think the cases will be clubbed? Because there are such cases in Andhra, Maharashtra, Tamil Nadu, and other states.
See, Supreme Court, they will do it in routinely. So far as this case, how much they succeed is a different issue, because it would also depend upon the facts of each case. But the Union of India, they would like to test this, and then they will, the approach of the Union of India. In every aspect, whenever there is a cases of this nature, they would like the issue to be kept alive, because diversity of opinion is always possible in the high courts.
One follow-up question that I would like to ask you is on the issue of dependents in India inheriting an account, and that number may be in thousands, given the fact that a lot of Indians work abroad, open accounts abroad, and have nominees who are permanent residents of India who may have never traveled abroad. And the penalty is pretty high in case you fail to disclose. Given the social dynamics of India, what are the issues that may crop up for such people who are nominees of account holders?
See, technically, nominees are only beneficiaries. They were not aware and they were not part of the earlier the accounts being there. If it comes to their notice at a particular point of time, and if before notice is issued, if they say that these are the disclosures are made in the voluntarily, if they go and make the voluntary disclosure, at best it gets assessed. Even that is also, I do not see much of a scope there. Based on the provisions of the Act, it is meant to. This is a futuristic act rather than with respect to the old transactions being brought in. When you look at the provisions more carefully, what I understand at this point of time from a facie is that it is more to ensure that in future they don't do. So it's a more of a preventive measure to ensure the prospective aspects rather than to bring in the old closer transactions.
Point well taken. I'll go to Ramya Suresh. Do you think a Pandora's box of litigation has been opened because litigations are sprawling up in all the states? What is essential for the litigations to come down in these kind of cases? Do you think an outreach program is in order, or the way the investigations happen, there will be litigations as far as this law is concerned for the foreseeable future?
Sure. So, Tarun, see, the law came into force almost a decade ago, right? And like Sir mentioned, there was a window for disclosures for 12 months to disclose whatever was held at the time and hadn't been previously disclosed, right? So therefore, the lead time as far as the legislature is concerned has been considered, and they have factored that in, and that's the teething period they'll need to make the disclosures that hadn't been made up until then, right? Progressively after that, then it becomes a matter of usual course that assets that need to be disclosed are duly disclosed on an annual basis as and when returns are filed. Now, as far as undisclosed assets as are defined in the Act, what it talks about is assets held by a person with respect to which the person does not have an explanation about the source of investment in such assets, right? So it's not that there is no consideration for bona fides here. Of course, like if you look at situations where there are nominees in India with perhaps no knowledge of accounts elsewhere, and they only devolve upon them upon the person abroad passing away or something of the sort, there is therefore an explanation of the source. So as and when it's disclosed, as and when it's supposed to disclose, or as and when it is there's a show cause notice issued and you have explanation, the bona fides will be considered. I think the purpose of the legislature is to bring out whatever was undisclosed assets up until the passing of the legislature. So given the lead time that was offered in the legislation and the amount of time that has passed since, it's now more a question of regular sort of compliance with the necessary disclosure requirements and building up on information on familial assets, or even the devolution process, just to build that awareness within the families. We're somewhat at a better position now, certainly since compared to a decade ago and much before that, where there's more discussion around these aspects within the family. Of course, there are situations still where money is not really a comfortable topic to be discussed, but it does now come up more often than it did before, and hopefully these loose ends are tied and there's information available on how devolution is happening, who the nominees are, and it's information that is available and is disclosed in a compliant fashion.
Point well taken. We'll take one last comment from Justice Chella Kodandram before we end.
Well, as I said, the possibility of more notices being given and at this point of time on account of various understandings which the Government of India has with various other governments, more particularly with respect to the hidden assets. I doubt very much the window which has already been provided was not utilized by many, except for the few, probably who were not aware of the act or who were more confident. That's the reason you do not find much of news coming with respect to under this act at any point of time in last 10 years. I have come across with respect to this particular act or any disclosures having been made or any discoveries having been made. See, if you look at the discoveries having been made, there's hardly any disclosures in the newspaper or the news coming. That's because the window which was given earlier, that such kind of act or amendment is coming, the information was in news for many of the people, and they all had an opportunity to square up, and you do not find today anybody talking about Swiss money being there, so much of Swiss money, except for the sake of elections. You don't find anybody making any even noise, including the political leaders, except saying that Modi promised and he did not bring back money. And that's because there is nothing there to bring back, undisclosed as of now, it looks like.
Now we are joined by Justice R.S. Chauhan, who served as Chief Justice of the Uttarakhand High Court. Now is a practicing arbitrator who does national and international arbitrations. Good to see you, sir. And on this issue, looking forward to some interesting insights from you.
Thank you, Tarun, for inviting me to your program. And I always look forward to being part of your program.
So this Justice Nagprasanna's very good judgment that has been authored on the Black Money Act that can't be used retrospectively. In the next 5-6 minutes, if you could give your observations for the audience.
I had the pleasure of going through Brother Nagprasanna's judgment, and I must say it's a very finely balanced judgment. It balances the legislative intent and the intention of the parliament in trying to curb, black money. And as we all know, black money is one of the biggest menace of our country. As rightly pointed out in the statement of object of the act, black money undermines not only the national economy, but even the national security. Therefore, it is an extremely important piece of legislation. Yes, the parliament is trying to control the offenses which are being committed by the people. But at the same time, the question is, whatever happens to the constitutional provisions? Because the Constitution and the criminal law generally is more on the side of the liberty of the individual. Therefore, the question is, how do you balance these two conflicting interests? The need to control the danger of an offense to the society, to the nation on one hand, and the individual liberty. And I must say that Brother Nagprasanna has done a fine job of balancing these two conflicting interests, number one. Number two, interestingly, it does not declare Section 72C as unconstitutional. What he does say is that legal fiction cannot be stretched to the point that you are going to create a give a retrospective effect to a criminal offense, because that will not withstand the scrutiny of Article 20. And there, I think he's absolutely correct that a statute cannot override the provisions of the Constitution, and that's a well-settled principle of law. But I'm so glad that he has applied to it and said an act which was committed when it was not even declared to be an illegal act in 2007, 2008, and 2009, and the Black Money Act comes into force in 2016, you cannot use the legal fiction contained in Section 72C to say that act committed by you so many years ago is an offense, and therefore I have the right to prosecute you. And therefore, I think it's a leading, an enlightening judgment. And I must say it adds another link to the series of enlightening judgment we have always had from the Karnataka High Court. And since I was part of that High Court, I'm very proud of the fact that, yes, it has been given by the High Court where I worked for 3.5 years.
Glad to know that. One follow-up question I want to ask you.
Yes.
Given that there are such cases being filed all over India, do you think the Supreme Court will give some clarity on this? Because, of course, the Income Tax Department will escalate this to the Supreme Court.
Oh, absolutely.
What do you think see happening in the Supreme Court in the days to come?
That is difficult to predict because Supreme Court may take a different view depending on how the case will be argued. But I'm just hoping that Supreme Court, being the highest constitutional court, would realize the significance and the importance of the provisions of the Constitution, and especially of Article 20. But let us see. In fact, it's very interesting, and I'm glad this issue has been raised by the Karnataka High Court because this will certainly require the Supreme Court now to clarify what the law is all about. So in a way, it's a good opportunity for, and I think this judgment certainly should be appealed before the Honorable Supreme Court, because let us settle the issue once and for all. And
yeah, because
that clarity is needed, and that clarity can only be given by the apex court. So I'm in fact looking forward to see how the Honorable Supreme Court will tackle this issue.
We all look forward to it, and because cases of such nature are being filed in all states of the country, so
Yes.
the Supreme Court can give a clarification. We thank you that you spared time for this show and you shared your opinion, and we will look forward to inviting you again when this matter is adjudicated for by the Supreme Court, so that this issue is settled once and for all. But a good judgment of the Karnataka High Court, which you also said is a court that you had the opportunity to serve, and it is something that we value that could join us. Thank you so much.
Well, it's been entirely my pleasure, and thank you very much again for inviting me.
Point well taken. I really appreciate Justice Chella Kodadram, Ramya Suresh partners, Saraf and partners joining us on this important development that happened in the Karnataka High Court. Thank you, viewers, for tuning in. Look forward to our new series on transfer pricing that comes out soon. But thank you for joining us on the internet. Thank you so very much.
Thank you. Thank you.
Thank you for having me, Tarun.